Know more about your world.
eNCA.com.
In a landmark ruling, a U.S. court has decided that 2 German companies cannot be held liable for allegedly aiding and abetting the apartheid government in racial attacks and injustices. South Africans who said they were victims of apartheid crimes and torture were amongst those who took the 2 German companies, Daimler and Rheinmetall, to court. A U.S. judge ruled in New York that the German companies could not be sued under the Alien Tort Statute, which allows non-U.S. citizens to bring cases in U.S. courts over international violations. Judicial Service Commission spokesperson and former TRC Commissioner Advocate Dumisa Ntsebeza joins us now. Good morning, Mr. Ntsebeza. Thank you for coming in this morning. Well, let me begin by asking you, this case has been dragging on for the last 10 years. Why is it such a landmark case, and what are the implications of this ruling?
Yes, I think first of all, the case is more important for what it has allowed to happen. You will probably recall that at the end, since 2002, when the cases were first filed by us, with Professor Lungisile Ntsebeza, my brother, as one of the lead plaintiffs, the so-called Ntsebeza plaintiffs, what has happened is that the case has been tested, the law in the US has been tested in terms of who can be sued, where can they be sued, and whether the American courts have got jurisdiction for matters that happened outside of the United States. And as a consequence thereof, there were now 5 companies that were left. It was General Motors. General Motors went under, and then what remained was Ford Motor Company, IBM, Rheinmetall, and Daimler Chrysler. Now this court has said, the Supreme Court in the United States, in a case called Kiobel, has decided on at least one issue, and that issue is, can the law apply extraterritorially? In other words, can it apply to countries outside of the United States? And I think the Supreme Court of America, the US Supreme Court said it cannot. And I'm paraphrasing because it's a very complicated area. So it said it cannot. You cannot sue companies other than, because there is an assumption at law that that law was intended to apply intraterritorial, in other words, to apply within the United States.
Now, aside from the companies that you just mentioned, which other companies have had similar lawsuits brought against them? Have we seen these types of cases before?
Oh yeah, there are so many. In fact, that is part of the reason that this judge has decided to allow this case to go on the basis that 2 of the companies that were left over of the 4 I mentioned, that is Ford Motor Company and IBM, it is because other circuits in the States, there are about 11 circuits. The 9th circuit, for instance, in Nestle, in the case of Nestle, has decided no, corporates can be sued, because that was one of the questions that had to be decided. Can you sue corporates instead of suing natural persons for violations of international human rights law? And that court, in the Nestle case, just recently said you can, provided you meet certain requirements. The one other question that had to be determined by the court is whether aiding and abetting has to be proved on the basis that the violator had intention. In other words, so-called the criminal standard of mens rea. Was there a clear intention on the part of the violator to violate the human rights of the victims? Now, some courts are saying, well, you don't really have to show that there was intention. Some others say, well, you have to show that. So the jury is still out on the question of whether corporates as corporates can be sued for violation of international human rights law. And we're still in with a chance, because the court has said, you must come back here. Perhaps amend your claims in such a way that they show that A, there are enough facts to show that Ford and IBM are companies which are American companies which can be sued in the US courts.
And what about the issues around these kinds of cases playing out in foreign courts? I mean, should they not be playing out here at home? It is a South African issue, you know.
Yes, ideally that should be the case. In fact, that is one of the reasons, that was one of the vexing problems that we faced with in 2002 when we decided to launch these cases. But what we were confronted with in 2002 was whether the South African courts would not claim that this is a matter that should be happening in American courts because the companies are American courts, in which case the South African courts would say we don't have jurisdiction over this. That was our thinking in 2002. It's still our thinking because there are few exceptions to that rule. So we are suing in the United States because there is at least a law, even if it's a law that dates back to 1789, which had been enacted to curb piracy insofar as piracy was seen as a crime against the law of nations.
So now that this ruling was made, what will be the next step? Are there other processes that can be taken to further this lawsuit?
Yes, indeed. As I say, now the victims, the Nsebeza plaintiffs, the Khulumani plaintiffs, are in with a chance. They can still go back to that court and say, okay, now that we have said corporates can be sued, we are going to be able to show you why they can be sued.
All right. Well, thank you very much. That's all the time we have for this morning. Thank you very much for your time.
You're welcome.
Advocate Dumisa Nsebeza, Judicial Service Commission spokesperson and former TRC commissioner.
You deserve to know more.
eNCA.com.